Any reason why not?
Objection.
Grounds.
Argumentative and irrelevant. Sustain.
Grounds for the sustain.
Mr. Brooks, please ask your next question.
Grounds for the sustain.
Welcome everybody to The Loud Little Ducky. Today we are going to discuss objection grounds. If any of you have been watching the Darrell Brooks trial, you will know that he loves to say grounds, even if the grounds have already been stated. So we're going to go into what the grounds are and the objections, and they work vice versa. So, little cartoon over here. Objection, Your Honor. Objection. I kind of forget why, but I think it was good. Hold on. That's kind of how Brooks is in this trial. And once you object, the judge will overrule the objection or sustain the objection. But let's jump into our first objection. Objection, Your Honor. Counsel is leading the witness. Leading is going to be our first one. And leading is defined as suggesting a particular answer to the witness. An example would be, wasn't it Jane you saw pointing the gun at John? You can't insert what you want the answer to be. What you should be asking is, what did you see Jane do to John? It does not say what she did or what she saw. It's asking her to say it. I object, Your Honor. Hearsay evidence. We have our little parrot thing over here because they like to just mock. A mockingbird. Those talking birds they're just straight hearsay. That's all they are. They just repeat things that they hear. They are the mascot for this objection. But hearsay is evidence given by a witness based on info received by someone else rather than personal knowledge. An example would be, Sue told me that she saw Jane point the gun at John. You cannot come in and testify about what somebody else saw. The only person that could come in and testify about what they saw would be Sue. So this isn't going to work. There's also a thing called double hearsay or hearsay within hearsay, and that can be an example that was in the Darrell Brooks trial is Brooks was reading a police report that the police officer wrote while listening to the witness. So the witness gave it to the police officer wrote it down, and then Brooks is now asking the police officer if this is what they said. And so, kind of like telephone with the double hearsay and hearsay with the hearsay, is you can't ask them, oh, did you tell them this or did they tell you that? The only person that can talk about what they said is who said it. And it's telephone where you go around and you say the same stuff, but throughout the process of it going from one mouth to another, it gets changed up a little bit. And so it's not as reliable when the more hearsay it goes through. Hopefully that makes sense. Let's move on to the next. Here we have the three little pigs in our little cartoon, and the big bad wolf, and it says, In my opinion, the flimsy construction of their homes indicates the pig's desire to be eaten. So that is this witness's testimony. That's not a fact. That's just an opinion. That is what he thinks. But he cannot prove that just because the three little pigs only didn't have better houses because they wanted to be eaten. But if they had a nicer house, then it wouldn't be fair game to eat them. That's not facts. But it says opinion is witness cannot give an opinion that goes beyond common knowledge unless the witness is a recognized expert in the field. Example of this is any witness can say they thought the car was in poor condition, but only a witness who is a mechanic could provide opinion about the condition of the brakes. So you could say, yeah, this car is a piece of crap. Or that somebody could say, oh, that car is a piece of crap. And they're judging it from the outside. But mechanically, maybe there's nothing wrong with it. And so if you don't know the issue because you're not the person, which me, if something goes wrong in my car, I have no idea what it is. I have to go take it to an expert, a mechanic, so that they can figure it out. All I know is it's not working. It doesn't work. So we need people that actually have knowledge in the field to state these things. Because a trial is about facts, not opinions, not feelings. Little cartoon here is, Your Honor, let the record show that Mercury was in retrograde when my client stole the vehicle. And the judge says, I don't see how this is relevant. And then there's some gossip from the attorney to his client saying, such a Scorpio. So this is relevancy. And a question that has no relevance in the case. So Mercury being in retrograde has nothing to do with a person stealing a vehicle. So it doesn't need to be brought up. It does not matter. Like, okay, a bunch of stuff happens during the time somebody else is doing something. It doesn't mean that it pertains to this particular case or crime or whatever the matter is. Another example would be asking a murder suspect about pizza they eat all the time. That question has no bearing or relevancy to the case of the murderer. So it doesn't matter what pizza they eat all the time. It makes no difference in this trial. So that is what relevancy is. Here we have a woman that says, rather than respond to whatever was in that speech, I'd like to stick to my prepared remarks now. And this is objection nonresponsive, which is a reply that does not really answer the question. So usually it's them going off and just saying whatever they want to say. They want to get out what they want to get out, and not what the person that is doing the testimony examination is asking. So an example on this would be, question, did you get the knife from the kitchen? Answer, I came home, then heard a dog. Okay, so the answer, I came home, then heard a dog, has nothing to do with the knife or the kitchen. So this is non-responsive. They did not answer the question. They might have wanted, maybe they were going to say this and then lead up to that, but you just answer the question straight. You don't go into extra stuff. Answer the question and the question only. Don't say anything else. So it should be, did you get the knife from the kitchen? And then the answer could be yes or no. It's just a straightforward question and it needs a straightforward answer. Objection vague. So our guy over here says, so some stuff happened and some people were like, whatever and stuff. And some people were there. And so like, no one was hurt, fortunately. We have no extra information or know anything more about what happened from this sentence. It didn't need to be said because it was a waste of breath. That we're supposed to be more informed after somebody makes a statement, not scratching our heads like, oh, okay, you didn't answer anything. And I have no clue what you're talking about. So it says the vague, ambiguous, or my favorite, unintelligible objection is used in reference to a statute written in language that is so indefinite or lacking in precision that an individual of ordinary intelligence is forced to guess as to its meaning. An example of this would be, tell me what all you did. And, well, that doesn't really say anything. Tell you all I did when? Yesterday, today, 5 weeks ago. It's not specific. And in court, you have to have specificity. So the question should be, tell me what you did on May 16th, 2007. And that may be even too vague still. So they may have to say, tell me what you did May 16th, 2007 between 5 and 6 p.m. That's not vague. We're asking for specific details about a certain time. So there is no confusion about what the witness is supposed to testify to. We're not all questioning like, okay, when did this happen? All right. So unintelligible. Argumentative. And we have the little old lady that maybe lives in a shoe, or maybe Mother Goose, who says, the attorney cross-examining her is stating, surely you don't expect the jury to believe that fairy tale, madam. So argumentative is questions directed to the witness, trying to influence the witness by inserting the attorney's interpretation of the evidence. Example being, question, how often did you get your brakes checked prior to the accident? And if the witness answers, twice a week. And then the attorney comes back and says, you expect this jury to believe that you got under your car twice a week, every week, to check your brakes? And it's like, see, you can't be stating that. Because basically they're stating, yeah, right. I don't believe that you did this. And that is putting what they believe out into the jury so that the jury believes or hears that same thing. And you can't be doing that. You cannot argue with the witness either. You are to ask questions, get your answers, or you can object with your grounds, and everything else can continue. But you are not to argue with the judge or with the witness or with counsel while you're in court, especially in front of a jury. Objections, speculation is defined as if a witness does not know a fact to be true or not, but testifies about it anyway. A witness must have personal knowledge of a fact to testify about that fact and put it into the court record. An example is the opposing attorney asking a witness, "What do you think your sister was thinking when she left?" Well, this witness can't know. This witness has no personal knowledge of what was going on in her sister's brain, so she can't testify to that. The only person that can testify about what the sister was thinking is the sister. Otherwise, it's speculating. And the little cartoon kind of sums it up over here. I object, Your Honor. How much wood would a woodchuck chuck if a woodchuck could chuck wood is purely conjecture. That's a mouthful. Y'all should say it too. And that is speculation, because how does this woodchuck know how much a woodchuck could woodchuck if a woodchuck could chuck wood? He doesn't know how much wood a woodchuck can do. Or maybe he knows about how much he can chuck wood, but maybe the other woodchucks don't chuck wood as much. They're not chucking wood as fast as this other woodchuck. I know that's a lot of confusion, but it's speculation. We cannot know that. Other than it just being this crazy sentence or question, it's supposed to be funny because you're supposed to speculate how much wood could the woodchuck chuck. So we cannot speculate about the woodchuck. We cannot speculate about somebody else's thoughts because they are not our own personal knowledge. Objection asked and answered is defined as repeatedly asking you or your witness the same question, hoping contradicting answers will be given, or hoping that the client will give a better answer than the one given before. So this is not the way to go about trying to impeach somebody, is by asking the question twice, basically. And if their answer the first time you asked it was yes, and the second time you asked it was no, you can't say, but oh, you just said, well, you already asked that question. So it was asked and answered, period. If you want to impeach, you need to do it the right way. You need to have some extra proof, but you don't get to ask the same question over and over again. Example, did I write you a check for $100? Answer is no. Question says, you're saying I didn't write you a check for $100. The answer is no, you didn't. And then he goes to question once again, I'm talking about last year. You remember the check I wrote you, right? And of course he's going to say no again, but this is where the attorney objects because it's now like 3 times they've asked the same question. And this witness said no the first time it was asked. So that ends there. Move on to the next question. We'd be there all day if we just sat there asking the same question over and over again. And it gets lost in all of the chaos. And so our cartoon here is, in the future, please say I object rather than that is total bullshit. So you cannot stand up in court and say, this is bullshit. You need to say I object. Hollering is not the way to go on that, and you would definitely get in trouble for it from the judge. Objection compound means when two or more questions are combined as one question. Compound questions are not allowed because they can confuse the court. Also, it needs to be clear for court records on which of the questions is being answered. An example is, why did you go back into the house and what made you think it was a good idea to then take the children away? Well, that's two questions. So when somebody starts to answer, you might not know which, why, and what they are talking about, because sometimes people answer the last part of a question first and then answer the first part of the question last. And so it needs to be one question at a time. So you can say, why did you go back into the house? Let them answer, and then say, what made you think it was a good idea to then take the children away? And then they give the answer. So we have the answers to both. It's clear. It's going to be clear in the court records. It's going to be clear to the jury. Just one question at a time. And so our cartoon example is, isn't it true that you deliberately stepped on a crack because you were angry with your mother for giving you a timeout on the day in question? And so it should be, did you deliberately step on a crack? And he could say, yes. Was it because you were angry with your mother? Yes. Were you angry with her because she gave you a timeout? Yes. So all of that big, huge questions about all these things, we now have a clear walkthrough of the answers. Because what if he says, yes, I did deliberately step on a crack. Yes, I was angry with my mother. What if he says, no, it is not because of timeout? Maybe his reasoning was for not giving him dessert. So, so it would be, when you mix all those together, he could be saying yes and no, and that doesn't work. We need to know what the yeses are and what the nos are for. So that's why you ask it one question at a time. Do not compound things. Here we have our little cartoon. Doesn't really have anything to do with foundation because it was really hard to, I really couldn't find anything for that. But it says, you can't object, you're a juror, which is, I think, what the jurors in the Darrell Brooks case would like to do. Kind of like everybody at home watching the trial is, object, all this is dumb, you're on video. That's what we would all like to say, but of course we don't get to object or put our 2 cents in. We just have to sit there and listen to it and hear objection grounds all the time. And say, I object. I'm tired of him saying grounds. None of us can do that. We can when we're yelling at our TV, but we can't do it if we're a juror. You can go home and write, or on your scribble notes be like, oh my God, I do not like this person. But you can't be saying it out loud. So, but anyways, back to it. Objection foundation is if a person failed to explain the background circumstances when answering about a specific fact, that the witness must set the stage and explain how a witness knows the information. For example, a person can't testify that it was a certain person's voice on the phone without first explaining that the witness had spoken with the person many times over the last few years and the call came from the same number. So he can't say, whose voice was that? And you say Bob. Okay, well, we kind of need to know why this person knows that voice. Not just because that leads us to be like, well, how does she know that? How does she know that that was Bob? Well, so we need to set the foundation. So setting the foundation would kind of be like, do you recognize the voice on this audio? Yes. Have you heard this voice before? Yes. And maybe you could ask when, or do you recognize the number that called you? Yes. How do you know that? And who does that number belong to? Bob. And is that Bob's voice that you hear on the phone? Yes. So it's a foundation. Yes, it seems longer, but we have to know the reason why this person knows that. You can't just say, I know this. You have to have the stuff to back it up and support it. And so that's what laying out the foundation is going to be. Because now, when he asks, is this Bob's voice, or whose voice is that, and they say Bob, you're going to be like, oh, okay, well, yeah, she talks to him all the time. She's called him, or he's called him from that number, and everything like that. So it gives more credit to the statement. Objection narrative calls for a narrative. When a witness talks nonstop without interruption, the witness must answer the attorney's question and only the attorney's question. They can't just get on the stand and talk about things not asked, which we talked about that earlier in the video, that you just get up there and you answer the question. Don't be given more or less. Because sometimes when you do give more, sometimes they might object and say narrative, but other times they may just let you keep talking and you might hang yourself with the words you're saying. You might slip and say something that you probably shouldn't have said. And because you not said it, now the opposing side can come in and ask about that and bring that to the attention of the jury. But also, if you're doing a narrative, your attorney, if it's direct examination, your attorney should be like, let's just answer the question, like rein it in, make it like yes or no, to where you're not asking for a narrative type thing, and stuff like that. And so we have an example as a prosecutor asking the victim to describe what happened on the day of the crime. The victim probably can't discuss all the events that occurred on the day they were victimized without talking uninterrupted for a long time. Because they would start with maybe breakfast and them getting up, and they would need to say everything that happened until the person went to bed. And so that is a long thing. You can just go in with, what time did you get up? 9 o'clock. About what time did you go to the store? Noon. Did you meet up with anybody at the store? So you can do the narrative through one question at a time, but you're not just going to have it to where the witness just talks and talks and talks. Here in our cartoon illustration, it says, and how did it make you feel when those officers called you the perp? So he's going to talk about his feelings. And those aren't always simple. So you can't just go on and on about that. You can say, were you mad when the officers called you that? Did it offend you? Things like that, because you can still get the answers to those questions, but you need to change the form of the question so it does not call for a narrative. Objection, facts not in evidence. Our cartoon over here says, no, I wasn't the getaway driver. If I was, I would have gotten away. Well, those are not facts and evidence, because you can get away from a scene, but it doesn't mean that you got away from the crime itself or got away with it. It just means that you were the person who drove away. So that I would have gotten away, that is not a fact, that's an evidence. Because, well, if he was the getaway driver and then he's here in court being charged with something, well, obviously he didn't get away. So we need to make sure that they're facts based on evidence. You can't just be talking about anything that we have no proof of. Trials and courts are all about facts and proof, and it is thrown through testimony and evidence. So if a question references a fact that has not yet been presented or accepted as evidence, it can be objected to on that basis because it assumes a fact that has not been established. And the example here is question. Where were you at the time of the accident? The answer, I was standing at the bus stop right near the southeast corner of the intersection of Main Street and 7th Avenue. Question, what did the driver of the black van throw out the window? So it would be objection, not in evidence, because there was no prior testimony on, 1, there was a black van, 2, the witness could see the driver, and 3, the witness saw the driver throwing something out the window. If he wanted to get these things, he needed to go with what color was the vehicle, or how would you describe the vehicle? And they could say, oh, like van. And they could say, well, what color was it? And you could say black. Did you see who was driving the black van? And then you could say, did you see anything? Did the driver do anything when you saw the black van? But you need to introduce these things into it, which is laying the foundation so that this is all brought up. Maybe to show a clip, and you could say, is this accurate of what you saw? and they could say yes or no. Let's publish to the jury. And what is that vehicle? Or is this the vehicle you saw? Yes. Is this a black van? Or describe that vehicle, and he could say it's a black van. And then you can like maybe move the clip up and say, what did you just see in this video? And he could say, the driver throwing something out the window of his van. So those are ways to get it. Once again, you still get the questions that you wanted answered. You just have to make sure you do it properly. More objections. These are not going to be all the objections that there are out there. There are others. Some of these objections also have subcategories that go with them. Here are a few of the other ones that you've probably heard in several of the more recent trials. We've got badgering, which means that you're just hounding and kind of harassing them in a way. Then we have calls for a legal conclusion, because you are not to give legal conclusions. That is what the court is there for. That is what the jury instructions are for. The only conclusion that needs to be given is the facts. So don't be quoting the law and saying, oh, this is what malice is, or what is malice. And it needs a legal conclusion. You can't just be giving what you think it is, and the witness is not the person to be answering those types of questions. I think that is how that one goes. It just, I think, pertains more to the law. And then we have beyond the scope. Beyond the scope could be such as like the Darrell Brooks case, where somebody came in just to testify about the porch. And they saw him on their porch, and he asked to use their phone, and he looked a certain way and all of this. They can only answer questions about that. They can't, that witness cannot be asked about the parade, because if they didn't go to the parade and their interaction with this defendant is not based on the parade, it's beyond the scope of this witness's testimony. They can only speak to this certain part because they weren't physically there and have personal knowledge of anything else other than the person being on their porch, if that makes sense. Then we also have prejudicial and probative. Prejudicial means, of course, it is going to be more damaging to this person if this is given. And probative meaning the opposite. It can't just be like, oh, this person's an angel because they did this, or oh, this person is awful because they did that. Because those things that are prejudicial or probative, they possibly don't actually have anything to do with the case. But if we hear them, we're going to be like, of course, and make up our minds there. Kind of like when we hear about, let's say, a person has been convicted of possession charge, but the case is on manslaughter. Well, the fact that they've been convicted of a possession charge previously doesn't mean that they were in possession of it now. And if there's nothing to back up these things, that's going to be prejudicial, because you can be like, oh yeah, of course they're guilty because, you know, he was smoking weed then, and now he probably was smoking weed, and that's how he killed this person or something. When that doesn't actually mean that that is true. They just may hear it and think, of course, he's guilty. Or you hear all these things about, oh, they did this and this and this, and they would never hurt a fly. And so you're like, yeah, okay, we have somebody who smokes weed and has been in trouble for it before, and then we have this person over here who just does all this volunteer work, and she's a nurse, and she's just all these things. And of course you can paint certain characteristics, but we need to make sure that they are fairly based and that it is not more prejudicial or more probative. Then we have objection privileged. In the Depp v. Heard case, you will remember seeing Adam Waldman's deposition, where they kept asking and the objection kept being attorney-client privilege. And so that means they have information that they do not have permission to speak of. Your doctor, if you didn't sign the thing saying yes, they could talk about it, because it's all between you and your doctor, or you and your attorney, the attorney-client privilege, and your attorney can't just go out there saying all this stuff without your privilege, your permission. It is privileged information that nobody else needs to know unless you say it's okay. So that stuff is protected under the law. And nothing can be drawn from asserting privilege, because that doesn't mean that that person is hiding anything. It just means they legally do not have permission, and if they break that privilege, then they could be in trouble and liable. Then we have nothing pending. That is when a witness maybe starts talking, but nothing was asked. So you're like, objection. Would you have the witness refrain from just talking until I pose a question? And they could be, oh, I thought you asked a question. No, there was no question pending. Because you don't want them to just sit there and talk. Only talk when you have to. Only answer what you were asked. Don't start speaking about other things. Because you can get your side out if you want to continue on, because your attorney should be able to do the cross or a redirect to clear those things up. Just answer the questions. Then we have objection incomplete. This could be incomplete evidence, an incomplete report, a video that's incomplete, and everything needs to be full transparency, not half of this and then the other half is elsewhere, and it's completely taken out of context. So we don't need anything incomplete. And then we have objection counsel is testifying. This one goes with if you've seen the deposition of Amber Heard after when she was filing for a divorce and trying to get her permanent restraining order, you will notice that the counselor, her attorney, was saying all this stuff. He was saying this and this and this, and he's not supposed to be saying it. She's supposed to answer those questions, not the counselor or the attorney. The attorney is just there to make sure that there's a fair trial and represent you and ask the questions. They don't get to sit there and tell the story. It's not story time from somebody else. We're not writing a biography that's narrated by anybody else. The person that is testifying will give their own autobiography in these matters. So there's the objections. Hopefully Brooks learns these. Probably not, but these are the grounds. These are the objections. And usually when you object, you state the grounds right after it. So you do not need to ask the judge for the grounds, because the opposing side gave you the grounds for their objection. So that is all for this video. If you like this kind of content, hit that like button, subscribe, and I will see you in the next video. Bye.